placed on the record. First of all, let's talk about jury instructions. Both counsel have been given copies of proposed jury instructions, had a chance to review them. And Ms. Kozlowski, any additions, deletions, or corrections you wish to suggest?
No, Your Honor.
Mr. Piazza.
Yes, Your Honor. We did request as lesser included of counts 1, 2, and 3, the criminal sexual conduct in the first degree. We asked for criminal sexual conduct in the second degree, as well as assault with intent to commit criminal sexual conduct involving penetration. The also lesser included of assault with intent to commit criminal sexual conduct involving contact, as well as assault and battery. In relationship to the assault with intent to commit CSC, I believe cited People versus NICK-ENS 470 Michigan 622 as it indicated that it is a lesser included of the CSC first. I asked that those be given.
Mr. Piazza, you ran through about 2 or 3 different issues there. See if we can break them down in bite-sized chunks.
Okay.
So that the prosecutor can respond to each one of them.
Okay.
The first one was lesser included offense on second degree. Is that correct?
That's correct.
Ms. Kozlowski, your response.
Thank you, Your Honor. Criminal sexual conduct in the second degree encompasses an element that criminal sexual conduct in the first degree does not have. For CSC in the second, the proofs have to show that it was done for a sexual purpose. In the counts of CSC first degree that we have charged the defendant with, there's nothing in there that pertains to sexual purpose. It is based on the ages of the parties. And I do believe CSC in the second degree is not a necessary lesser included.
All right. I will deny the request for that particular instruction. You can see People versus Nix, that's NYX, located at 479 Mich 112, a 2007 case. Because second degree criminal sexual conduct is a cognate lesser of the charged offenses, I will deny the requested instruction on that particular issue. Now, Mr. Piazza, let's go to the next one.
We had requested assault with intent to commit criminal sexual conduct involving penetration, in which I did cite People versus Nickens.
All right. Ms. Kozlowski.
Your Honor, similar to the CSC second, assault with intent to commit penetration also encompasses an element that CSC first does not have, the assault element there. We've not had any proofs to suggest that there was assault that actually occurred prior to an assault with intent to commit penetration. It would be our position again that assault with intent to commit is not a necessary lesser included.
All right. And I'll deny the request again. The case of People versus Nickens that Mr. Piazza cited is factually distinguished from the case at bar, and therefore it's inapplicable to request or instruct a jury on that particular matter. Also, Mr. Piazza, you requested an assault and battery lesser as well. Is that correct?
As well as assault with intent to commit CSC involving contact.
Okay. And those, you wish to respond?
Your Honor, my argument would be the same. Thank you.
Okay, and my ruling would be the same as well. Because assault with intent to commit criminal sexual conduct is a cognate lesser of the offenses charged in this case, no jury instruction will be allowed as well. And that goes along with the assault and battery along the same lines. Anything else, Mr. Piazza?
I don't believe so, Your Honor.
All right. And Ms. Piazza, you wish to place something else on the record wholly unrelated to the instructions?
Well, with the instructions too. Mr. Henderson, in the jury instructions, we did make requests for lesser included, but there is one lesser included that's going to be given to the jury that's attempted criminal sexual conduct involving penetration. You understand that? Yes. And you and I discussed this, is that correct? Yes. And you are in agreement with asking for the lesser included of attempted CSC second. Is that correct? Okay. And you understand the, if convicted of CSC second, that is a maximum of 5 years on which the habitual offender status, and it could still create a life offense, and then the violent habitual offender, 25 years, and the mandatory minimum. You understand that? No, you understand that. You know, but you still wish the attempted CSC second, attempted CSC first to be given as a lesser included for the jury to consider. Is that correct? Okay. Is the court satisfied with that?
I am.
Thank you. Also, Mr. Henderson, you understand that you have a right to testify at trial. You understand that? Yes. And you also have a right not to testify at trial. You understand that? Yes. If you do testify at trial, the prosecution will be able to cross-examine you. You understand that? Yes. If you decide not to testify, the court will give instructions to the jury that they cannot use that against you in any way. You understand that? And you and I have discussed the matter about testify or not testify. Is that correct? And it's your decision at this time not to testify during this trial. Is that correct?
All right,
Have a seat.
satisfied with that as well. Anything else for the record, Mr. Piazza?
Yes, Your Honor. Mr. Henderson, we did subpoena several doctors for the defense in this particular matter. You understand that? And we went over their testimony together, and I told you what they were going to be testifying about. Is that correct? And then after the testimony concluded yesterday, including that of the same nurse, we decided not to call them the doctors in this case. Is that correct? And you're in agreement with that decision. Is that correct? Yes. Thank you, Your Honor. I have nothing
All right.
further.
Anything else, Ms. Kozlowski?
No, Your Honor.
All right, I believe we are still waiting on the. So, Mr. Piazza, when we do bring the jury back in, I'll say, Mr. Piazza, you may proceed. You can stand up and say, we rest, and then we
Yes.
go into closing arguments.
That'll be fine, Your Honor. Thank you.
Okay.